Welcome back to the deep dive. Today we're plunging into a subject that's just so foundational to law, to ethics, and really to political philosophy.
Yeah, it really is.
It's a deep-seated question that every single functioning legal system, from ancient empires all the way to modern democracies, has to confront. And that question is, what is the true nature of reliable evidence, especially human testimony, when the state is the one seeking it?
And you've hit on the core tension right there. We're getting right to the heart of integrity versus expediency. This deep dive, it's not just another discussion about human rights, though that is, of course, a huge part of it.
Right.
It's really about the very definition of legal validity.
Mm-hmm.
We're examining this incredible principle that a statement, one acquired through cruelty or coercion, must be rendered legally null. And this is the part that's so key, even if it happens to be factually accurate.
That's the part that always gets me. That tension, factual truth on one side versus legal nullity on the other. It's the whole intellectual core of what we're exploring today. So our mission today is to really unpack this absolute, this universal prohibition of torture. We're going to trace its roots across millennia. And for this, we're drawing from excerpts of some fascinating research titled The Jurisprudence of Inviolable Truth, Prohibiting Torture, which was compiled by Mr. Zahir Ahmad Mir.
And this document, it provides a remarkable roadmap for us. It really lets us track this one singular principle, this rejection of forced statements, all the way from ancient religious decrees through global treaty codification and then right down into modern national constitutional law. We really want you, the learner, to quickly grasp the profound depth and the widespread acceptance of this critical legal boundary.
I think the moment you realize that the law is designed to intentionally reject information that might actually be true, that's when you get it. You realize this is about something so much larger than just finding facts. It's about procedural purity.
It's the ultimate boundary, the ultimate line drawn against the state. The law is essentially standing up and saying, the means by which information is acquired defines its inherent trustworthiness. Full stop. And if those means violate the dignity of a person, that information is tainted. It's tainted beyond redemption. The system would rather suffer the possibility of failing to find a guilty party.
Which is a huge risk.
A huge risk. But it would rather take that risk than sanction its own corruption.
That feels like an enormous sacrifice for a legal system to make, though, to consciously choose this higher moral ground over what might feel like the certainty of evidence.
It is, but it's a necessary choice. It has to be.
Yeah.
Because once the system sacrifices its morality for expediency, once it allows the use of force, it loses the very moral authority upon which the entire structure of justice is built.
It eats itself from the inside out.
Exactly. The only way to ensure the long-term integrity of the whole system is to establish a rule that is absolute, a principle that is truly inviolable.
Okay, let's unpack this. We're starting with that core philosophical and legal principle, the engine that's driving this entire jurisprudence. Let's jump right into the fundamental legal principle found in the source material. It is the immediate practical rule that just governs this whole space, and it's stated so simply. Confession extracted by force is void.
That phrase is everything. It's the operational mandate. In any courtroom that's operating under the rule of law, if the defense can prove that force was used, the evidence is immediately stripped of its utility. It's gone.
So it's not even debated at that point. It's just out.
It's out. This is a crucial procedural safeguard, and it's designed to act as a preventative measure. By rendering the confession totally useless, the system removes the incentive for state agents, police, military interrogators, to even think about resorting to cruelty in the first place.
Why bother going down that road if it leads to a dead end in court?
Precisely. But the sources, as you said, they don't stop there. And this is where it gets really interesting. The deeper insight, the philosophical justification for this voidance, what the law calls the ratio or the reason for the ruling, is what really elevates this whole discussion. And it declares, truth obtained by cruelty is legally false.
Okay, that statement, that one right there, it feels like a paradox. How can something be truth and legally false at the same time?
This is one of the most powerful legal declarations possible. We have to spend some time here unpacking this linguistic and philosophical assertion. Notice the language. It's not soft. It doesn't say unreliable or tainted or even untrustworthy.
No, it says false.
He uses the term legally false. It's an incredibly strong, absolute statement.
So help me unpack that crucial distinction. If a statement is just called unreliable, it implies that a judge or a jury might have to spend weeks trying to figure out if the person was really coerced or whether, despite the coercion, the statement still lined up with external facts. It sounds like a messy, subjective rabbit hole.
You've nailed it. That's exactly the problem. Declaring it merely unreliable forces a complex factual determination, like a mini-trial within the main trial, over the degree of coercion used and what its effect was on that specific individual's will.
Which would be almost impossible to prove definitively.
Almost impossible. So the law, by preemptively calling it legally false, avoids this subjective trap entirely. It asserts that the moment the input condition, the cruelty, is met, the output, the statement, is immediately categorized as invalid, period, regardless of its potential correspondence with metaphysical reality.
So the law is prioritizing the process over the potential content. Why is that radical prioritization necessary? Why can't the law just say, okay, yes, the method was terrible, but look, the confession led us to the murder weapon, so we can still use the weapon as evidence?
Because that is the slippery slope that destroys the entire system. It's a classic legal problem. If the law allows the use of the fruit of that coercive act, it tacitly, or even explicitly, endorses the initial illegality. This touches upon a very famous legal doctrine, often known as the fruit of the poisonous tree. The idea is quite simple. If the tree, the initial act of cruelty, is poisonous, then any fruit it bears, the resulting confession, or any evidence discovered because of that confession, is also inadmissible. It's all poisoned.
That's a powerful analogy. The initial corruption really does taint the entire chain of evidence that's derived from it. If the court lets the state benefit from its own wrongdoing, it's pretty much actively incentivizing that same wrongdoing in future cases.
That is the core public policy justification. The main function of declaring coerced evidence legally false is not primarily to ensure factual accuracy. I mean, we already assumed coercion rarely yields reliable results anyway, but to deter the state. It removes the entire functional advantage of using force. If a confession you get through torture solves the crime but can't be used in court and can't even be used to justify finding other evidence, then torture suddenly becomes a useless, high-risk activity for the state agent.
So this mechanism, it serves as an inviolable boundary for state action. It defines what the state is not allowed to be.
Precisely. The legal system is essentially drawing a very clear line in the sand, saying, we refuse to participate in this methodology. This decision, this choice to prioritize human dignity and procedural integrity above the expediency of acquiring information, it defines the fundamental difference between a constitutional democracy and an authoritarian regime. The former cannot sacrifice foundational morality, not even for a guaranteed informational gain.
But I have to ask the question that I know is on a lot of people's minds. Doesn't this frustrate justice in really high-stakes cases, say in counterterrorism, where intelligence is critical and time is short? How does the law justify letting a potential threat walk free just to preserve some kind of abstract integrity? That's the practical real-world challenge.
And that is the perpetual tension. It's been debated across every legal tradition for centuries. But the counter-argument is that systems that allow for exceptions, even seemingly small or well-justified ones like the famous ticking time bomb scenario, they inevitably slide into habitual abuse.
The exception becomes the rule.
The exception becomes the rule. Once you admit the principle that achieving a desirable outcome can justify cruelty, the exception rapidly overtakes the rule. And think about it. The person who gets to decide the bomb is ticking is also the person administering the coercion. There's no check on that power.
So the law has to be a prophylactic, a kind of absolute barrier. It has to eliminate the judge's ability to try and balance the moral crime of coercion against the practical benefit of the evidence.
It's exactly right. The legally false rule acts as an absolute prophylactic rule. It eliminates the need for those messy inquiries into the subjective state of the coerced person or the degree of physical pain they endured. If cruelty was demonstrably present, the testimony is legally non-existent. The state must find its evidence through legitimate means, through careful investigation, due process, and warrant procedures, or not at all.
And this teaches you, the listener, a fundamental lesson about reliability, even outside of a courtroom. If the legal system, which is literally optimized for finding truth, institutionalizes this deep distrust of coerced information, we should all be highly skeptical of any statement generated under duress, fear, or some profound power imbalance. The legal system just gives this distrust a very powerful name: legally false.
It connects back to the very idea of human agency. A coerced statement is not an act of conscience or memory. It's an act of compliance. The individual isn't speaking to communicate a fact. They're speaking to stop pain. The law recognizes this complete destruction of agency and refuses to validate the compliance that results from it. And this philosophical anchor is incredibly resilient, which is why we find its expression so early in history.
That's a perfect bridge. That resilience, that understanding that the state must be restrained, is not some modern invention. It has deep, deep roots in ancient jurisprudence, which leads us right into Section 2.
The strength of this principle of inviolable truth, it really becomes evident when you look at its deep transnational and transtemporal lineage. This idea that coercion invalidates testimony, it precedes modern constitutional documents by centuries. It's not new.
And the source material provides a very specific, really compelling historical anchor point that demonstrates this early recognition. And that's the Islamic precedent set by Hazrat Ali, RA, who forbade coercion in confessions.
This reference is profoundly significant. Hazrat Ali, the fourth caliph and a cousin of the Prophet Muhammad, was one of the earliest and most influential figures in the development of Islamic jurisprudence, or fiqh. His rulings in judicial matters established foundational ethical and legal standards that were, later systematized by scholars.
So to put this into context for our listeners, we are talking about the 7th century. This is a time when many contemporary legal systems around the world often relied very heavily on corporal punishment or oaths under duress, or even trial by ordeal to extract information or determine guilt.
Exactly, which is why this ruling stands out so starkly. Hazrat Ali's prohibition against coercion in confessions, which was often emphasized in the context of needing true repentance and a voluntary admission, established a clear, state-imposed limit on investigative methods. It insisted that confessions had to be voluntary acts of conscience. They had to reflect the inner truth of the accused, not just be mechanical acts of self-preservation against pain or threat.
So what were the practical mechanisms they used to enforce this prohibition in that early Islamic context? I mean, it couldn't have just been a suggestion. It had to be a rule of evidence.
Right. It operated primarily through the established hierarchy of qadis, or judges. The qadi's court had a very high standard for accepting testimony. If there was any indication, or even just a suspicion, that a confession had been obtained under duress, and that could be physical restraint, or a threat, or even manipulation.
So psychological, too.
Yes. The qadi was obligated to reject the confession entirely. This rule was integrated into the broader Sharia rules of evidence, which have always emphasized procedural fairness.
This really illustrates a concept of due process existing extremely early in legal history. It suggests a level of sophistication that recognized the inherent danger when the state, acting as the prosecutor, also controls the means of interrogation.
Absolutely. It acts as an early expression of the rule of law restraining the sovereign or the state apparatus. By explicitly forbidding coercion, this jurisprudence ensured that the acquisition of information could not come at the cost of the accused's dignity or physical integrity. It codified the understanding that forced testimony is unreliable testimony, and it's rooted in a broader ethical framework that emphasizes mercy and justice, or adl.
But let's play devil's advocate for a moment here. Systems, even those founded on really high moral principles, can suffer lapses. Did this prohibition always hold up perfectly across the many different Islamic empires and centuries?
Well, historical reality is, of course, always complex. The legal theory was crystal clear, but its implementation definitely varied depending on the political stability and, frankly, the ethical rigor of the ruling caliph or a local governor.
Sure.
There were certainly periods and regions where political necessity or personal cruelty led to deviations from the rule. However, and this is the important part, the standard itself remained inviolable. Legal scholars and jurists consistently referred back to the rulings of figures like Hazrat Ali to criticize and correct state actions when the prohibition was violated. So the principle acted as a constant normative yardstick.
That's the key synthesis point, then. The prohibition served as a foundational moral anchor. It demonstrates that the rejection of forced confessions has this deep transnational and transtemporal lineage. It predates modern constitutional documents by over a millennium.
And that allows us to view the modern global consensus not as some radical brand new idea, but as the inevitable convergence of diverse legal traditions all arriving at the same fundamental ethical conclusion. The line drawn by a 7th century jurist resonates directly with the prohibitions that are enshrined in modern human rights conventions.
It provides this incredible historical weight to the idea that rejecting torture isn't culturally unique to any one region or philosophy. It seems to be a shared recognition across humanity that pain yields compliance, not truth. And a just society cannot build its justice system on compliance born of fear.
This is the continuity of the principle. The prohibition is fundamentally about protecting the integrity of the judicial process itself. And this sets the stage perfectly for our next section, which shows how this ancient moral clarity was formalized and codified on a global scale in the modern era.
So we move now from that ancient philosophical and religious precedent right into the 20th and 21st centuries. Following the immense political upheavals and atrocities of the mid-20th century, there was this global effort to codify absolute minimum standards of human behavior and legal procedure. This principle of inviolable truth had to move from being a local legal tradition to becoming a universal international obligation.
This is the age of codification, and the source material highlights the central instrument in this entire process, the UN Convention Against Torture, or UNCAT.
For our listener who might be familiar with the concept but not the specifics, what is the nature and the scope of UNCAT? What does it truly represent in international law?
UNCAT, or formally, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, is one of the foundational global human rights treaties. It was adopted by the UN General Assembly back in 1984, and it came into force in 1987. It represents a global, unified consensus among the vast majority of sovereign states. By ratifying it, states formally agree to be legally bound by its provisions.
And what specific obligations does it impose on these signatory states regarding the prohibition of torture? What do they actually have to do?
The obligations are extensive and they are mandatory. First, it requires states to take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under their jurisdiction. They have to pass laws against it. Second, and this is crucial for our discussion, Article 15 of UNCAT states, and I'll quote a part of it, "Each state party shall ensure that any statement which is established to have been made as a result of torture shall not be invoked as evidence in any proceedings, except against a person accused of torture as evidence that the statement was made."
So that is the modern international embodiment of the ratio we started with. Truth obtained by cruelty is legally false. Article 15 institutionalizes that rule on a global scale.
Absolutely. It removes any and all ambiguity. Furthermore, UNCAT imposes requirements that go far beyond just mere prohibition. It defines torture, which is critical for legal enforcement. It mandates that state parties have to investigate any allegation of torture, they must prosecute or extradite those responsible, and they have to ensure victims have a right to redress.
Wait, you mentioned extradition, so UNCAT also addresses the issue of sending someone back to a country where they might face torture.
Yes, and that is one of its most critical contributions. Article 3 establishes the principle of non-refoulement. It's a French term. It means no state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he or she would be in danger of being subjected to torture.
Wow.
And this obligation is absolute. It cannot be derogated from, not even in times of war or public emergency.
That elevates the prohibition beyond just internal criminal procedure to a core matter of international security and diplomatic conduct. It means the prohibition isn't just about what a state does on its own soil, but how it interacts with the entire global community.
It underscores the consensus that the prohibition on torture has achieved the status of jus cogens.
That's a term of art we should probably define for our listeners. What is jus cogens?
Jus cogens, or peremptory norms, are fundamental principles of international law that are so universally accepted, so essential to the international community, that no state can contract out of them. They are non-derogable.
So they're like the unbreakable rules of the international game.
Exactly. The prohibition of torture is one of the most widely recognized jus cogens norms. This means that even if a state signs a separate treaty with another country that allows for the use of torture in certain circumstances, that treaty would be null and void because it violates a peremptory norm.
So the global community has collectively decided that torture is not a policy choice. It is an absolute evil, universally prohibited. It's a fundamental minimum floor for civilization.
Precisely. And this is the synthesis point. UNCAT is the modern, formalized architecture built directly upon that historical foundation we discussed, and it's mandated by that core philosophical ratio. It takes the moral standard set by Hazrat Ali centuries ago and translates it into a binding, internationally enforceable legal obligation.
I can really see the power of that continuity now. The philosophical distrust of cruelty we started with in Section 1, it found an ethical precedent in Section 2 and was finally locked down by a global legal structure here in Section 3. But often, these treaties can feel very abstract. We need to see how these high ideals are actually fought for, defended, and applied within a specific national jurisdiction.
That's why the case study from the source material is so vital. It shows the principle actively fighting for life in a national context.
Let's shift our focus now and ground these global principles in the supreme law of a nation. The source material highlights the example of Pakistan, focusing on a specific constitutional mandate and its judicial enforcement.
This section is so important because it illustrates how international obligations like UNCAT are domesticated, how they're given real force on the ground. The anchor here is Pakistan's Article 14 to the Constitution.
What does that specific article mandate and what is its significance?
So Article 14 of the Constitution is dedicated to the inviolability of the dignity of man. Article 14.2 specifically states that no person shall be subjected to torture for the purpose of extracting evidence.
And that's not just a law, that's in the Constitution.
Correct. This is not a mere police regulation or some legislative act that can be easily changed. It is part of the supreme law of the land, inserted specifically to protect the fundamental rights of the citizen against the power of the state.
Placing that prohibition in the Constitution gives it immense power, doesn't it? What does being supreme law signify in practical terms for the average citizen?
It means the protection is robust. It can't be easily watered down by ordinary legislation. Any police regulation, any emergency decree, any standard operational procedure that authorizes or even just encourages coercive questioning is immediately challengeable. It's susceptible to invalidation by the courts as unconstitutional. It is the ultimate legal defense for the individual against state overreach. The courts are obligated to enforce this protection because the Constitution is their primary mandate.
This transforms the abstract principles of UNCAT into a direct, enforceable individual right. If a state agent uses force, they aren't just violating some moral code, they were violating the foundational contract between the citizen and the state.
Exactly. But as we know, a constitutional article is only as strong as the judiciary's willingness to defend it. And this brings us to the active, interpretive work of the courts, which is highlighted by the Shehla Zia line of cases.
Right. When we talk about a line of cases, we're talking about more than just one instance. This suggests a history of judicial engagement. So how does the Shehla Zia precedent continually reinforce and clarify the constitutional prohibition against coercion?
The Shehla Zia line of cases is critical because it represents the judiciary actively defining and policing the constitutional boundary that's set by Article 14.2. The court has consistently used this precedent to remind the state that the protection of dignity is expansive. It affirms that the principle of confession extracted by force is void is not a dead letter, but an actively enforced mechanism.
So let's delve into that judicial interpretation. Historically, I think a lot of systems have narrowly defined torture as just severe physical violence. Did the Shehla Zia cases expand the definition of coercion or torture under Article 14.2 beyond just physical brutality?
They absolutely did. And this is the crucial nuance that makes judicial interpretation so vital. The courts realize that Article 14.2 has to protect the dignity of man in its spirit, not just in its letter. So the judiciary has expanded the definition of coercion to include things like psychological pressure, prolonged inhumane detention conditions that are designed to break the will, sleep deprivation, or even threats against family members.
So the judiciary is essentially saying, the state cannot achieve through mental cruelty what it is prohibited from achieving through physical brutality. The goal is to ensure the confession remains truly voluntary, stemming from free will.
Precisely. The court's interpretive role ensures that the prohibition remains relevant and effective against evolving forms of state power and more sophisticated interrogation techniques. It constantly reminds state investigators that any tactic that's aimed at breaking a person's psychological or emotional resistance to force a confession violates the supreme law.
And what are the immediate consequences within the court system when a defense successfully demonstrates a violation of Article 14.2 based on this Shehla Zia interpretation?
The consequences are the direct implementation of that core ratio we started with. The evidence is inadmissible. It's thrown out. Furthermore, because of the judicial commitment demonstrated in this line of cases, the courts are also empowered to mandate action against the state agents who are responsible. This is judicial accountability in action.
And that addresses the practical challenge we talked about earlier. It's not enough to simply declare the evidence void. The judicial system has to actively enforce sanctions to remove the incentive for coercion in the first place.
The judiciary, in this context, acts as the final guarantor of procedural purity. When investigators are aware that the superior courts will not only reject their coerced evidence, but might also initiate proceedings against them personally, it creates a powerful deterrent effect. The judges are affirming that the rule of law must prevail over the practical pressures of expediency, the very tension we started this deep dive with.
This is the critical link in the chain of inviolable truth. We've moved from philosophy to historical precedent to global codification, and finally to the active, day in and day out judicial defense of that principle on the ground. It shows the principle is actively being defended against powerful investigative bodies that are always seeking quick results.
And the success of the Shehla Zia line of cases in upholding this broad interpretation of dignity and freedom from coercion, it serves as a beacon. It illustrates that constitutional rights, when they're actively defended by an independent judiciary, can truly function as the shield of the citizen.
So, what you, the listener, should really take away from this entire segment is that the principle of inviolable truth is complex, it's deep, and it's constantly being contested. Yet it remains the supreme moral requirement for a state that claims to be just. It is not something simply signed in Geneva. It is actively, rigorously upheld by high courts worldwide. This journey has taken us through millennia of legal thought just to understand the absolute prohibition on torture. We started with that profound philosophical tension at the heart of the matter, captured in the erasure that truth obtained by cruelty is legally false. The law chooses integrity over expediency.
We established the historical and ethical depth of this idea, tracing it all the way back to the foundational prohibition set by Hazrat Ali, R.A.I., in early Islamic jurisprudence, proving that the rejection of forced evidence is an ancient transnational moral anchor.
We then explored the global convergence of this principle, seeing it codified as a universal and non-derogable obligation through the UN Convention Against Torture, UNCAT 8, which established a minimum floor for human dignity worldwide.
And finally, we saw how these abstract ideals are made concrete and enforceable through national jurisprudence, exemplified by Pakistan's Article 14.2 and the active, expansive defense provided by the Shehla Zia line of cases, which ensure judicial accountability and procedural purity.
The key takeaway for you, the learner, is clear. The principle of inviolable truth transcends time, culture, and specific legal systems. The state is consistently prohibited from using cruelty, not merely because it's immoral, but because it fundamentally destroys legal veracity. The moment force is used, the system loses its ability to accept the result, and that protects the system from its own temptation towards corruption.
It is the ultimate statement that the integrity of the state's methods is non-negotiable, and that procedural purity is more valuable than informational gain. In a way, the law sacrifices the potentially useful fact in order to save its own soul.
And this raises a challenging, final, provocative thought for you to mull over as you conclude this deep dive. We focused entirely on why the foundational institutions of justice must declare coerced truth legally false. The rule exists to maintain institutional integrity.
But if the validity of a statement is inseparable from the ethical nature of its extraction in a court of law, how should you, in your own critical thinking and your engagement with the broader world, approach information or arguments or data that's generated under conditions of ethical compromise, duress, or a profound power imbalance?
If the law demands purity of process before validating a claim, shouldn't we apply that same demand to the information we consume every day, asking not just, is this true, but was this acquired ethically? Is the source pure enough to fully trust the content?
That's the question that echoes across the centuries of jurisprudence we've just examined. Thank you for joining us on the Deep Dive.
Until next time.